Welcome back to the Making International in Korea video series. In this video, I'll be building upon the previous presentation on states and explain the concept of the state responsibility. The formal definition of state responsibility is the legal consequences of the international wrongful acts of states, namely the obligation of the wrongdoer on the one hand, and the rights and powers of any states affected by the wrong on the other. So the concept of the state responsibility have to be repeated again and again because very nature of international law touches upon this concept. Legal consequences of an international wrongful act of states. On the other hand, the rights and powers of any states affected by the wrong the other. The issues when a state becomes responsible for something it does in international system is known in international law as state responsibility. When considering this question, it is important to note from a legal perspective whom or what can be held responsible. This goes to issue of legal personality. Legal personality is the capacity of a legal person having rights and obligations. This is an issue which is quite familiar in domestic law in relation to liability for civil wrongs. Legal persons have or owe duties to others. When those duties are breached, the legal person is responsible and remedy is owed. At the same time, in the same context, under international law, the states are charged with responsibility for their international wrongful actions. Let me first touch upon the traditional rule of state responsibility. The traditional rules of the state responsibility consist of the customary rules that evolved from an old practice of European states and from cases brought before international arbitral tribunals. These customary rules provide that if a state violates an obligation imposed by an international rule, involve the international responsibility for such a violation. Consequently, it had to make a reparation for the breach, and by the same token, the injured state was entitled to self-help. It could take a forcible action, for example, armed reprisal and war, or non-forcible measures, for example, economic sanction, suspension, or termination of treaty, and so on and so forth. These rules on state responsibility were rudimentary and not very well developed and lumped together with the substantive rules concerning the treatment of the foreigners. They did not specify the general element of the violation of international law, nor did rules establish the precise remedies and consequences of the international wrongful action. For instance, it was not clear whether there was a requirement for intent when it comes to establish responsibility for state wrongful conduct. Another issue left unresolved was whether a state could also be responsible for neglected conduct. Moreover, it was not clear what exact remedy was available. For example, you may refer that the Fukushima nuclear, the waste issues between Korea and Japan, and the recent invasion of Russia to Ukraine can be understood with the framework of the state responsibility. Also, many issues related between Korea and Japan, which are related with the post-colonial issues, for example, forced labor issues and the military sexual slavery issues, also can be understood the state responsibility of the rules. Under these traditional rules, the choice of remedies, such as compensation, restitution, or satisfaction, was left to the state parties concerned. Furthermore, it was left to the injured state to decide whether and what stage to resort to enforced measures as well as what measures to take. The older version of international law was a self-help system, wherein a state that suffered the breach of international obligation would make its own determination as to whether there was a breach to begin with, and then determine when and how to remedy the wrong. State responsibility amounts to bilateral relations between the delinquent state and injured state. The relation between the delinquent state and injured state is very much important to approach. Only if the parties enter into negotiations and reach agreements could they establish a dispute settlement mechanism that would take such decisions as to state responsibility out of the hands of the parties involved. Given that emphasis of the traditional rules on state conduct, the conduct attributed to the state that violates the international rules, focused upon acts performed by state officials, while individuals could only be liable for breaking international law in cases of piracy and when they acted as state officials, such as being a member of the armed forces of a belligerent party. There are more examples to give into this context. Let me move to the contemporary rules of state responsibility. With the development of international community, the law of state responsibility moved beyond merely the state responsibility in a context of the treatment of foreigners and the relatively simple rules that encompass the state liability. The new rules on state responsibility clarified and gave precision to a number of elements of state responsibility, such as clarifying when fault is necessary and the nature of damage for a state to be considered injured by the wrongful acts of another state. Further, the issue of how to respond to breaches of international obligations advanced beyond self-help, with its potential for armed attacks, has presently required the pacific settlement of disputes before resorting to countermeasures. As I give you examples, in many cases between Korea and Japan, in terms of the post-colonial issues, compared to women, forced labor issues, and let's say the different issues of the recent case of the Fukushima, the nuclear disaster, the waste dumping, what kinds of the rules of the state responsibility can apply in this context, whether older one or new one, and what kinds of context can be the best interest for Korea and can be resolved and it can be approached in this regard. The new rules also distinguish between two categories of the state responsibility. The responsibility for ordinary breaches of international law and aggravated the responsibility for violation of the fundamental general rules. Additionally, while the old rules of state responsibility provide for very limited individual liability for breaches of international law, there has been a development of individual criminal responsibility for state officials and private persons who can be held accountable for serious breaches of international law, such as war crimes, crime against humanity, and genocide and terrorism, both in time of peace and in time of war. You may see that the difference or distinguishes the terms between new rules and old rules in terms of the state responsibility. And when you apply for this rule of state responsibility, you have to remember that what kinds of rules you will apply. Now, also military leaders, as well as senior politicians and members of cabinet, industrialists may be held accountable for any international crime. For example, if you looking back to the past, once the war is held, the military leaders sometimes waive their accountabilities. And also senior politicians and sometimes the industrialists who built the economic the project in the local, the third party or third world. Sometimes they waive the accountability because they can argue that this is not belonging to any international accountability for any international crime.